Well, I'm not on item one at the moment, my lord. I'm making a prayer for adjournment of my lord. Item number 29.
29.
Yes.
Yes.
It will be after my lord 2 weeks.
On the prayer of Mr. Deepang England, counsel for the appeal and this matter after 2 weeks.
Should back to mention item number 6.
Yes.
May I pray that the matter may be taken consent after 2 weeks.
On the prayer of Mr. Arkoi, learned counsel for the petitioner.
Your
And
Lordship,
on the consent.
in this matter, this year has not been called for, perhaps, Your Lordship, because they are challenging the discharge or this alteration of the section during framing of charge.
On the consent of the learned counsel for the respondents, list this matter after 2 weeks. In the meantime, trial court records we call for.
Yes, Your Lordship. Deeply obliged, sir.
And Lordship 7 and 8.
What is this?
This
7
is
and 8 also.
7 and 8.
On the prayer of Mr. Arkoyo, 7 and 8. List this matter of 2 weeks.
Lordship, there is interim.
Interim order was earlier shall continue. Yes.
Much.
14.
Yeah, this matter is 6 or 20.
Why?
Because this case represented by Advocate Mononit Vishwas of Guwahati.
You are against the termination. You are against the termination of contract.
Contract. Against the termination of the contract. Already there is an interim order is also there.
We'll dispose it of today. What's there?
Advocate is not there. Maybe on 20.
You go for
I do not.
arbitration clause.
I do not have the file also.
Arbitration clause.
Yes, arbitration clause is there.
Take the second file.
Maybe on 20.
Take the second file.
File is there. Maybe on 20. I am not
The method
ready.
is very simple.
Yes, that is there. But maybe on
If there is a
arbitration clause is there. That is
efficacious alternative efficacious
alternative
remedy is
remedy.
there. Admittedly, you have not completed the works.
yes. That is why Lordship. This case is represented by this advocate. He has to. There may be
Your
many
name-
things.
Your name in the first
Yes, but
on top.
that is
It's
there.
a-
But
Well, dispose it off.
maybe on 20. Lord.
You avail the remedy under the contract agreement.
That client. So there should be a client instruction.
No, we'll
is
go by
required.
the merit of the matter, not by the client.
because there may be. Let the matter with on 20 laws. It will.
Heard Mr. T. Tapak, learned counsel for the petitioner. The writ petition
Repeat.
has been filed for against the termination of the contract. Please stop. Admittedly, no.
Arbitration.
In prime facie, it appears that the petitioner has not completed the works in terms of the contract agreement. Please stop. The contract agreement contains an arbitration clause, right?
Yes, arbitration clause.
Arbitration clause. Christoph, having considered above, this court is of the prime facie view that the petitioner should be relegated to the appropriate forum in terms of the contract in view of the settled proposition of the law.
Lordship, other than that, whether that arbitration is
facie.
efficacious or not,
Prime facie,
prima facie is there.
on the insistent prayer of the counsel for the petitioner, let this matter be listed on
On 20.
Why not 28? 2nd of August, September.
Maybe.
This court will be back
Yes.
2nd of September.
Okay.
Sorry. Anyway, list this matter on 2008-2024. On which date endeavor shall be made to dispose of this matter.
Interim order is there, that may be continued.
Interim order shall continue. Interim order to continue till the next date. Yes, yes,
May I please, Lordship? Lordship, I beg to make item 4 and 5.
yes.
This item is not supposed
List
to be listed
before-
before,
Just before any other appropriate bench without me.
after 3 weeks.
Not after 3 weeks, without me. That's all.
Lordship, I would like to mention item number 13 on behalf of State Counsel, Mr. Udeka.
13,
30.
30.
Yes, Lordship.
Why?
Lordship, he is only on medical ground rules.
You inform Mr. Deka,
Yes, Lordship.
just because we have directed them to pay the half of the award amount.
Yes, Lordship.
It doesn't mean that you should continue to adjourn the matter.
Okay, Lordship.
Continue to pray for adjournment. It's not done. And moreover, tell him in all the appeals, the grounds are same. It just appears to be cut and paste. There's no other grounds or similar. Because I've been observing it I've seen it last 2 weeks.
Yes, Lordship.
All these criminal appeals. Same ditto,
Lordship,
except
after-
the only the date of judgment and award is different.
Yes.
The grounds, everything is same. So have some. Tell him to look into it.
Okay.
All right, we'll adjourn it today.
Lordship, item number 11 also.
On the prayer of Mr. Your
W. Kumran.
learned counsel appearing on behalf of Mr. Udeka, learned counsel for the appellant. Item 30, huh?
Yes, Lordship. And item 11 also. Lordship.
Release this matter. After 2 weeks
Okay.
or 3 weeks,
2 weeks.
2 weeks. Item 11 also same here.
On behalf of El Kurdu.
Hmm?
On behalf
Okay.
of El Kurdu.
This is El Kurdu.
Yes,
Yes, next, please.
Lordship, I would like to mention item number 19.
Why?
The counsel Morik Bagra is out of station
Why is
And-
out of station?
due to his further medical emergency and in this honorable court already he submitted the letter of absence and even
No,
in causeless
just- Because council has submitted a letter of absence, it cannot be a ground for adjournment. All right, in any case, item
June 19.
19. On the prayer of Mr.
TRR
Huh?
TRR
T. Rag,
RAR.
counsel for the petition. The learned counsel appearing on behalf of Mr. M. Bagra, learned legal aid counsel. List this letter after 2 weeks on the ground that the learned legal aid counsel is indisposed due to his father's illness. Mr.
Much obliged.
Your Lordship, I would like to mention item number 9.
9.
Your Lordship, the leading counsel, Mr. A. Bhattacharjee, is severely ill and is under medication, Your Lordship. So he has asked me to seek for adjournment.
Mr. Your name?
This is go.
Learned counsel for the petitioner submits that Mr. A. Bhattacharjee, learned counsel for the petitioner, is under medical treatment for which he prays on behalf of Mr. A. Bhattacharjee for adjournment of the matter for another for 2 weeks.
2 weeks, Your Lordship.
Prayer is allowed. Let this matter be listed after.
May I, Lordship, I beg to mention item number 27, Your Lordship, on behalf of JGD. He's out of station, so matter may be adjourned today. May be listed after 2 weeks, Your Lordship.
Anyway, adjourn. On the prayer, Mr. So-and-so.
P. Tarin.
Appearing on behalf of so-and-so, huh? JJ. This will after 2 weeks.
2 weeks. All right. Lordship, I would like to mention item number 17. I'm appearing on behalf of T. Jammu.
We'll see. It in orders, we'll see. You wait for your. What's to be done?
My lord, at least since powers is inherent in any of the court, my lord. At least, my lord, CD may be called for.
Let us see next week. Next week. Because I'm finalizing it today. It will be placed today only. Before chief.
My lord, no object that the matter be listed after.
List this matter after a week. We'll fix that date. 14. 14. Will not say anything. Let's.
All right, Your Lordship.
That is the difficulty that has cropped up.
Yes. But problem is the procedure. Same thing.
May I please, Your Lordship?
Yes.
Lordship, this is a joint petition.
Yes.
The petitioner, one is the accused.
This issue, whether under 482.
Oh, yes.
528. It has been dealt with yesterday and this will be placed before the Chief Justice as per the procedure.
Okay.
According to this court, it should be filed under new act. I mean, the
New
GNSS,
provision.
New provision.
Because I have doubt because new laws.
That doubt, according to me, I have clarified, but that will the call will be taken by the division bench or the larger bench. All right.
Okay.
Have you gone through all those judgments?
No.
There are conflicting judgments.
Yes.
Various high court of the country,
Uh-huh.
and the coordinate bench has said it should be in the all leg supporting your view. So that I have deferred. I had a disagreement
With your Lordship permission, may I submit something?
No, that has been heard yesterday.
Okay.
This will be taken up next week. All right. This is the matter after next week. Huh? Sorry for inconvenience, but can't help it out.
Much obliged.
Same. You are in new provision.
No, all.
All. Why?
As per order was by the coordinate bench of this.
Okay. Same. Next week. Item 10. Item 10. Yes.
Yes, your lordship, respondent number 4 have to file the objection as per last report.
Who is respondent number?
It's written Orin Modi.
He is filed.
No, till now then.
Well, take it up. Notice has been served to you.
Yes.
You are good, I mean.
No, your lordship, I haven't prepared.
Hmm?
I haven't prepared, your lordship.
What?
I haven't prepared.
You
For-
prepared it now.
Maybe given next date for argument.
Okay.
My lord, I am for the respondent number 4.
Yes.
I may be allowed some more time to file objection.
What is there? What is there? What is the stage?
This is arising out of family dispute,
Yes.
joint dispute within family members.
Yes.
And there is a wrongful restraint trespass and criminal intimidation.
So,
What is the case?
so there is a prime proceed.
Yes, from
Charge sheet has been filed. Charge sheet has been filed.
Yes, my lord, charge sheet has been filed and there is a prima facie case against the accused person.
Show us. Show us. From where you are saying.
My lord,
Charge sheet has been filed.
yes, my lord.
You go through the, mister, you go through this. Find out any materials against the petitioner. You have the brief, madam? Do you have the brief?
No, I'm not aware of the facts.
Do you have the brief? Do you have the file?
Yeah, I have filed.
Go
Yes,
through
sir.
after some time. We'll dispose it of
Yes.
after some time. Go through it.
Yes,
Yes.
Lord. Yes. Lord, I have filed this appeal. I have filed this appeal under section 374(2) of CRPC against the judgment and order dated 11/6/2024 passed by the learned District Session Judge Alo.
You listed for the first time. Listed for the first time.
Yes.
Okay, we'll issue. Call for the records.
Lord, I also have
We'll
filed
admit this.
IA.
IA will consider next. We'll issue a notice on IA.
No, this is mandatory.
Coming for the first time.
Yes, yes, yes. I have been convicted and have been languishing behind the custody since after being convicted on 11/6/2024.
Any respondent?
Respondent? Yes, complainant.
Yes. We'll admit this and call for the records
Call for the
and
records,
then
yes.
we'll issue notice on our IA. All right. Where is that judgment and order?
Judgment Can we see page number 35, annexure 2?
35.
Yes. That operative procedure is
You come to
page number 78. my lord.
just wait.
Yes.
Heard Mr. G. Lolen and counsel. for-
Yeah, your worship, private respondent is not implemented.
He's there.
Yes, it's not,
He's there.
not implemented.
He's there.
Yes, complaint has to be implemented.
He's there.
No, in I, it's not there. Only state respondent has been implemented.
We'll take it up. Take up the appeal first. We'll see. In IA.
It's in
IA
I,
is not.
it's not
a
implemented.
party.
And
Heard Mr. G. Lolen and counsel for the appellant.
In main appeal, it is implemented.
This is an appeal under section
374-2.
375. Sorry. When did you file this appeal?
my lord,
When did you file the appeal?
appeal was filed on 7th of this month.
This month.
Yes.
Again, same problem.
Because I was convicted on 11/6/24, and I have filed appeal within a period of 2 months. So effectively, I have filed this appeal within a period of limitation.
The problem is whether it's the new, under the new act, I mean, BNSS or the old act. Obviously, you will say under the old act.
Yes.
Anyway, appeal is a, we'll take it different. See, this is also an appeal. We'll consider that this is a statutory appeal. And appeal is a continuation of trial. Right, so we'll not comment on it. We'll see. If they have any objection, we'll see. All right. Or Mr. G. Lolen, and counsel for that.
CRPC, we have any objection if it is continued on the CRPC.
You may have.
He may have objection, my brother.
Do you have any objection?
If same issue is still pending before this court for considerations, then it should be taken along with. Because
G.
section
Lolen,
may be
counsel
altered.
for the appellant. Next one. It's appeal. Section 374. Against the judgment and order dated 11/6/2024. Passed by the London District and Session Judge, Alam, in Sessions case number 01 of 2019. Whereby who is the appellant?
Appellant is a wife of the convict. And I also have
Wait.
annexure.
Sri Minkar Ingo has been convicted and sentenced to undergo imprisonment for a period of 6 months with fine of ₹1,000 for offence under section 448/34 IPC. And a period of 6 months with a fine of ₹1,000 for offence under section 323/34 IPC. A period of 2 years with a fine of ₹10,000 under sections 365, 34 IPC, and for a period of 3 years and 1 month with a fine of rupees 10,000 for offence under section 367 of the 34 IPC. Mr. Admit call for the 12 court records. Mr. Gitado, learned additional PP, appears for state. Mr. Gilole, learned counsel for the appellant to take steps to service a notice upon response number 2. What is the process? Same Eddie.
Yes, so it's
Register
supposed.
post with Eddie within 2 days, 3 days.
Yes, 3 days.
3 days from today. List after 4 weeks. In
What?
IA,
Yes,
what is to be done in IA?
I,
Your name is not the private respondent.
because complainant, I have made complainant as a party in my main case. But during the pendency of, because 389, during the pendency of.
You
appeal-
edit and you correct in.
Yes, my lord, I will do.
Mr. G. Lolan, learned counsel.
Yes.
Issue in IA, huh? Mr. G. Lolan, or Mr. G. Lolan, learned counsel for the applicant. Issue notice return in advance, 3 weeks. Mr. G. Lolan to file an amended court citation, implementing the complainant, public informant. Thereafter. To take steps for service of notice upon responding as well with the informant.
And
Mr. Gita enters, appears for state. List after 3 weeks.
3 weeks.
Call for the trial court records.
And my lord, I also would like to appraise before your honor is date, in my IA, page number 9, I have incorrectly written appellant prepared the present appeal amongst other on the following grounds. But grounds of bail is there. So this appellant prepared the present appeal amongst other on the following ground may be allowed to be expand this sentence.
You file an appeal. What did you file an appeal?
And
And 13,
yeah, 13 is same because I have been convicted under the same offense.
same.
Yes, 2 accused persons were convicted.
Same one. Mr. Obodi, learned counsel for the petitioner, applicant. Press for withdrawal of this bail application. Press it accepted. Next para, accordingly, the bail application stands dismissed on withdrawal. Why?
The case is registered in
Huh? Please stop. It is needless to observe that as and when non-bailable offense is when as and when a case is registered for non-bailable offense, the petitioner is always is liberty to approach the court for approach the appropriate court as may be permissible under the law. You record her name also.
Obliged.
Before that, before needless, MS so is also present. Is present. Additional PP, Yes.
Item number 16.
Service complete.
Service complete, even then.
Any records to be called? Record is there.
Record is there.
Huh?
Records are there.
Records are there.
No, it's
annex.
I have an X.
No, we'll call for the, which court? Which court?
Pasigat, session,
Sessions. Sessions.
no, district.
Or Mr. Arkoy, London Council for the appellant. And also has
Pasigat.
Mr. O Modi. London Council for the respondent number 4.
2 to 5.
2 to 5. Who is one? Who is one?
One is really he's represented by T. Jamo, who is absent.
No one appears for respondent number 1. Services are complete. List for admission here. And list for admission. The trial court records be called for.
Lordship, I'm appearing on behalf of T. Jamo for respondent. Some more time may be given to file objection.
And Mr. Arkoy, consent. Petitioner,
Yes,
transfer petition
yes.
from where to where?
From UPR to Teju.
Why?
Because the applicant is, petitioner is in rowing. And she is single lady, having one child. So for her, traveling here is bit difficult. So in any case, yes, respondent is the husband.
He's from?
He's from Doimuk. However, he is attending one maintenance case out there in Teju, rowing. Therefore, for him, traveling from here to Teju would not be.
Yes, what do you say?
Lordship,
Ladies first.
3 weeks time may be given to file
Since
objection.
you are appearing in some other cases there,
Lordship, for that I don't have any idea. I have been telephonically instructed by T. Jamo.
anyway, I heard Mr. Arkoy, London Council for the petition. Mr.
S. Irang, Lordship.
S.E. London Council for the London Council appearing on behalf of Mr.
T. Jamo.
Tijamo, London Council for the respondent. Press for it is granted. Further 3 weeks time to file an objection, if any.
Lordship, there is interim.
Interim order first, the liaison continue.
Much.
Item number 18. Lordship,
Yes,
this matter can be listed for hearing. I have received a paper book here. Lordship.
okay. And MS N Anju, London Council for the. You're for
Amicus for
Amicus.
appellant.
London Council. London appoint MS. Also, Jeeta. London, also heard Mr. Jeeta, London. Paper is ready. List for admission after 3 weeks.
Obliged. Item number 20. I know this application has been filed for quashing of FIR.
Yes. Why this has been listed today?
In the previous hearing, I think learned counsel of the respondent appeal. They have
Yes.
sought to file appeal, but today they are absent.
Heard Mr. Esquire, learned counsel for the petitioner. Also, Mr. Gita, learned additional PP for the state. Any record is required?
Yes,
Record has not been.
Non appears for the respondent number 2 to 16.
CD was called for, but not yet received.
Although by on 11/06/2024, the Mr. K. Moses for Mr. Learned Counsel for Mr. HROB praised for the time to listing the matter after 3 weeks. CD is called.
It was
CD
called
is
for.
required.
Not, yes, required, it's
You
required.
have received.
Not yet received. Not yet.
Registry to, or you'll produce the city.
Yes, I will.
Mr. Jitaro to
By next
the
day.
records. List for admission. After. No, before the list for admission. List for admission hearing. Then Jitaro, learn additional people to produce the scanned copy of the case diary.
Yes.
This for admission after 3 weeks. 2 weeks or 3 weeks? Make it 2 weeks.
Follow.
Hmm.
Item number 21.
Service, average service report in respect of respondent entry, list after 3 weeks.
Item number 23.
22.
22 June.
Your Honor, we have served the notice to respondent number 2.
Record in respect of respondent is yet to be received, list after 3 weeks. You just hear them, Mr. M. Pertin Junior. Huh?
Yes, sir.
M. Pertin within bracket Junior. And also Mr. Opada. Learn a special PP, my lord, SIC. SIC within bracket business, bracket close. Then you write. Absolutely. ID card is yet to be received. ID card in respect of respondent number 2 is yet to be received. List after 3 weeks. Okay. Yes.
Your Honor, we have served the respondent number 2 a copy of the order and an additional.
Mr. Suenso, learned counsel for petitioner, also Mr. Here the learned edition. Office note reflect, office note that 08/08/2024 reflects that service in respect of respondent number 2 is still awaited.
Your Lordship, issue of maintainability may kept open, Your Lordship. That is already reflected in the last 2 orders, Your Lordship.
If it is reflected,
Okay.
list
Outline.
after 3 weeks.
Much obliged.
Procedure, the joint petition filed by the respondent number 2 and 1. 2 is the victim in this case.
Yes.
The purpose of filing the joint petition is the quashing of the FIR and the caption.
Mr. Suenso, learned counsel for the petitioner, and also L. Hage learned edition, MS L. Hage learned edition. Record is received, list for admission in after 2 weeks. 2 weeks.
No, chief. Item number 26.
LCR. Not LCR. Trial court record. Trial court record is received. Mr. MS so appears for the petitioner and Zeta for state. Land discipline list for admission after
After 2
3
weeks,
weeks,
2 weeks, Lordship.
2 weeks. Okay.
There is an interim, Lordship.
Interim order was earlier. So
Much obliged.
yes.
May I plead your
Yes, sir.
lordship? This matter basically, we are challenging for posting of FIR because there was a land dispute between the two brothers. But basically, this is a civil matter, basically.
Yes.
So, in fact, they have inherited the ancestral land of my lord, may I see page 32, 33, 34. This is a document which shows that.
You cannot see it together one by one.
Okay, 32, my lord.
32, yes.
Yes, 32 is a succession of a property. 32
No,
matter.
no, I'm not concerned.
Yes,
Whether
my
there
lord.
is a prima facie case in the charge sheet, in the trial, in the record, that is, will consider, that's all.
My lord, my submission in here is that
Yes, you make your submission. Where's the FIR?
FIR is, my lord, FIR is in page 78, my lord.
78.
78. Yes, 78. 78 and type copy is in 8. Type copy is in 80. May I read that one?
Yes.
Yes. my lord. The first information contains officer in charge, Pasigat Police Station, East Coming District, Arunachal Pradesh, dated such and such. First information report that Sri Kaling Doru, age about 59 years, son of late Hagen Rugbo, resident of village. Kaling Rugbo is a respondent, is the brother of the petitioner's father, my lord. Talking about resident of village Yakbo, POPS Pasikat District ECM, Arunachal Pradesh. Do hereby most respectfully back to inform today at about 12:38 p.m. that is 28/0/2021 when I was doing erecting a boundary angle post demarcated by the neutral bodies over my lane situated at 5th mile area. All of a sudden, one Sri Sembul Doruk, son of Sri Tamon Doruk, resident such and such, is in relation son of my elder brother, Tamon Doruk, most illegally trespassed. The trespass, my lord, trespassed into my plot of land situated at 5th mile area and thereby scolding and abusing me and disrupt in doing the construction works of the boundary angle post and also threatened my labor. That Sri Semal Doruk also pushed and pulled me and attempted to assault me in presence of Sri Osup Lagos, Sri Talum Tain, Sri Padum Doruk, Sri Semul Doruk. Semul Doruk is the alleged accused here, is the nephew of the Kaling Doruk. Also on the earlier occasion, twice on dated 19/11/2020 and 20/11/2022, threatened and chased away my labor and thereby 20 nodes of angle posts got lost from the post and 35 bags of cement got damaged also. I paid sum of rupees 60,000 to the said laborers as an advance payment for the boundary angle post construction work, but the said work could not be completed as Samuel Duruk threatened and chased away for which I suffered huge loss to the tune of rupees 60,000 for such illegal act of this Samuel Duruk. This is important to state that here, as per the deed of amicable settlement dated 21/08/2020, and as per yes, well. So now question is, his base is on the amicable settlement 21/08/2020 between the two brothers. But that amicable settlement was not settled.
It's okay.
I will show you that.
No, no, it's okay. It's not
Yes,
necessary.
yes.
whether the amicable settle or not,
Yes.
it's not, we're not going to go into it. What we have to see is whether there is a privacy trespassing or not.
Yes, that's what. Because
Whether you settle or whether land belongs to you or the.
no, this is in the lane of grandfather. Because yes,
Your cousins.
this other respondent was constructing in the lane of the grandfather, my lord.
My lord, in one statement of the accused himself, he said that he trespassed into the land of the informant. But kindly,
Whatever, your cousins.
It's a grandfather, my lord.
Then really, same grandfather.
Yes, my lord.
my lord,
Same plot.
land has been already,
That has been settled now. Is the dispute is still pending?
no, my lord. No
It's
dispute.
not pending.
Oh, still pending, my lord. I will show you a document how it is still
No,
pending.
it's not, you don't have to establish here. What you have to, whether is there any dispute pending?
Yes, pending.
Have you filed any title suit or something like that? Or it's before the
Basically, we wanted to settle among ourselves, but then
You
other
settle, then come back.
respondent is not ready to settle the matter. In fact,
You
we
settle,
also went
come
to the
back.
Lok Adalat. We went to, we
Otherwise, we are dismissing it.
yes, I think if they are ready, we are ready, my lord. This is a ancestral land because there is no issue of trespassing because the grandfather's land is not yet settled. I will
He
show.
has said it's already settled.
No, I will show from my record that we have issued a legal notice. There is also a special committee also decided that this matter is yet to be settled.
Where it is?
I mean, this is there's a record shows that is settled. They said it's settled, but then FIR was lodged.
Why you
after
are
that.
so adamant? If there is any dispute, you resolve it. Why go for unnecessary?
dispute
After your blood related by
Yes,
blood.
nephew, in fact, the petition is the nephew of
My
the
lord,
respondent number.
See, if it belongs to you, if it has been settled, why unnecessarily punish him?
no, my lord, they enter into my land.
Your cousin, I mean, what your uncle,
Yes.
your uncle.
My lord, the land of the late father was already divided into two. And they enter into my farm.
It's okay. You may be have a right or he may, we're not concerned now for this purpose of this thing. What we're concerned is, since you are family or the related by blood, you should settle it. If there is any dispute regarding the ownership also, you decide, settle it. Why unnecessarily criminal prosecution?
My lord, charge sheet was filed under 447, criminal trespass, wrongful restraint, and criminal intimidation.
Criminal trespass, it is not made out, my lord.
If it is not matter, it's a matter of trial. You face the trial.
Even my lord,
But that's what we are challenging the FIR, my lord.
accused person is admitted in jail one.
We are challenging for a
trespass
first
into the
FIR.
land of.
Clearly, he has said that threaten and chase away the laborers.
Yes.
But there is no any statement of labor. There is no any witnesses which they have alleged that labor has threatened them. There should be some witnesses. There should be some labor in the charge sheet that that particular labor was threatened.
It is good for it. The charge sheet has been filed. So it's good case for you.
We are ready to settle. We don't have any issue because it's a family matter. We don't have problem. But then I don't know why they are so adamant.
My lord, there is no chance of settle.
Issue was that this is being ancestor lane. There was first agreement that till the registration, till the final settlement,
Yes,
the respondent should not do anything on this particular lane. But then,
yes,
There was a settlement dated 28/2020, but that was incomplete settlement.
yes,
Thereafter, there's another condition in serial number 10, 11, and 12. 10, 11, 12. That they have to execute another agreement.
No, we're
On the
not
basis-
concerned about. We're concerned about whether there is privacy case against the petitioner or not.
Pulling and pushing was there. If eyewitnesses were there, and
Is there any material that he has in Trespass?
Trespass is a, now this is a matter of fact.
Prima facie.
Prima facie, yes, it is a disputed fact, so
Any material to show?
yes, in para 10, 11, and 12 of the agreement, it
Why
is,
you should go for agreement?
no, they have not yet settled,
case-
demarcated the plot of land.
Any statement?
Statement, both accused and complainant has given a statement on their own favor.
Where it is?
This there.
Madam, there is a three witness,
Huh?
three witness.
Where it is?
Statement of three witness.
Two
Where are the
witness-
witnesses?
One is complainant himself. Another is complainant's son. Third is worker who was working at that point of time when there was some obstruction from the accused side while erecting boundary fence. And fourth is driver who carried the articles to the place. Question of trespassing is a disputed fact.
Page, your lordship may see page 108, you see 108.
Where is the charge sheet?
It is there.
Okay.
To show the trespass, the respondent has to show that there was really demarcation of that lane, madam. And he was really doing in his own plot. And in our case, that ancestor property was not finalized. Before the finalization, the respondent was trying to erect some pillars in that lane. Only the petition was, the issue was that he just said, don't construct there till the final demarcation of the plot after the final agreement. That was he only submitted before the respondent. After that, the respondent filed a FIR saying that he has trespassed in my lane. But then after that, there was another special meeting, my lord. Another final agreement was held in the after the filing of the FIR. It clearly shows that the lane was not fully demarcated between the brothers. So when the lane is not fully demarcated, no, he cannot claim that that land belongs to him because land is
Charge has been framed? Any charge has been framed?
It is not in the record.
You went there. You went to his place.
I went to my grandfather's plot, not his place, my lord. But what he is claiming is that is his plot, my lord. And that lane is not yet demarcated, my lord.
It's okay.
So I will just show you from the
Yeah, that's-
record. Even the RTI also shows that land is still in the name of the grandfather, my lord. My lord is in the page. I'll just take to the page 165. We have filed RTI.
Is there any record to show that the matter is still pending somewhere, any forum?
Not yet. I will just show that when land was settled after the FIR.
Huh?
After the FIR, land was settled.
Land was settled.
Yes.
Is it?
I will just show you that this one special committee report is on page 108.
What do you mean by in the special committee report?
I don't know. There was some they consider special this and that.
It's okay.
Yeah, but FR was prior to
What-
that.
yes,
Just
yes. Which page?
page 100. It starts from page 106.
Yes.
Yes, your lordship may see the 108 is 6 is the written handwritten, and the type copy is in 106.
Yes.
106, yes.
Then.
And then the 107 is the list of the witnesses who were present at the
Paper
meeting.
which was held at Boeing was special committees very for the land and Barbie or Dimag and Fanny. Say, someone Garu and Kalim Garu.
Demarcate and finalize the matter.
Demarcated from the gate of Taman Garu and then one motive. It's a demarcated by the committee later on.
Yes, later on, matter. Final demarcation is later on after the FIR is lodged. So it clearly shows that land was not demarcated between the two brothers.
This decided matter should not be disputed in near future.
Yes, Milan. Should not be disputed in near future, Milan.
Heard Mr. Esmo, learned counsel for the petitioner. And also heard Mr.
Jitado.
G. Tado, learned additional PP. And also heard Mr. and Mr. O. Modi. Learned counsel for the respondent. Number 2. Huh? Why so many?
I'm
Very
one,
good.
1, 2, and 1, 2, 3, and 4.
1, 2, and 3.
1, 2, 3, and 4.
Respond number 5. Next para. By filing this application, the petitioner has sought for, has spread for, has spread for enforcement of the section 482, 482 is here position, spread for enforcement of year case number 24 of 2024, corresponding to PS case number Pasigar PS case number 21 of 2020 under section 447, 341, 506 IPC, which is pending before the which court?
CGM, Milan.
Then the
CGM.
CGM. Pasigar. On the ground that there is no material to disclose any offense either in the FIR and the charge sheet. Next paragraph. The present case, the case emanates from the FIR. That is when is the FIR?
FIR is in page 178.
Who is that?
That is 28/2/2021.
emanates from from an FIR dated 28/02/2021.
20th February.
21, filed by the respond number 5, right?
Yes, Madam.
Stating that when he was stating that on 28/02/2021, when he was erecting boundary angle post demarcated by the neutral bodies over his land, situated at 5th mile area, all of a sudden, one city okay. All of a sudden, the petitioner, the one city, someone Doru, petitioner hearing, who is by relation is a son of his elder brother, illegally trespassed into his plot of land situated at 5th mile, and thereby scolding and abusing him and disturbed in doing the construction work of boundary angle post, and also threatened and said they were the laborers. It also alleged that it is also alleged that the petitioner had pushed and pulled the informant and attempted to assault him in the presence of three persons, namely Osup Lego, Sri Talom Tang, and Kadum Toro. It is further alleged that the petitioner in earlier occasion, on earlier 2 occasions, on 19/11/2020 and 20/11/2020, threatened and said they were his laborers, which resulted in the loss of resulted in the loss of angle 20 numbers of angle post and 35 bags of cement. It is alleged that due to the illegal act on the part of the petitioner, he had suffered huge losses. It is alleged that the land belongs to the petitioner. The land belongs to the informant, which has been settled, and it has been inherited. It is an inherited property. The on receipt of the FIR, the case was registered being Pasigat PS case number 21 of 2021 under section 447, 341, 506 IPC. Thereafter, after completion of the investigation, the police has laid the charge sheet against the petitioner under section 447 of 341, 506. Charge has not been framed.
Not yet. Not yet.
There is a disclosure from Sunil.
That's it.
Explain. The trial has comments.
Not yet, madam. Because
It is
The
submitted,
state.
it is submitted that though the charge sheet has been filed, no charges have been framed as on date. But it is pending trial before the. Not however, it is on date and the matter is pending trial before the learned CGM Pasigat. Mr. S. Mo, learned counsel to the petitioner, submits that on the bare perusal of the FIR, there is no no offenses disclosed. Mr. The issue, the dispute is with regard to the ancestral land, as the petitioner and the respondent number 5 are the descendant of same grandfather, and the petitioner is the nephew. No, respondent number 5 is the nephew of the petitioner. Nephew.
no, not nephew, it's younger father. Younger father, yes. Respondent is the younger father of the petitioner.
What do we call it? Younger father.
Yes.
Is it an appropriate word?
Can be uncle. Uncle,
What do you say? It's younger father or uncle?
Uncle, I think. Your lordship may uncle.
Say- Chota Bab.
Yes.
Huh?
Yes.
Chota Bab.
Chota Pita.
Chota Pita. Petitioner is the uncle of the respondent number 5, right? He submits that in the FIR, it is, though the petitioner, the respondent number, though the respondent number 5 has made a statement that the land dispute has been settled.
It was settled in 17-10-2020. There's a two agreement. One is 17-10-2021, and another is your lordship may note 31-10-2020.
Settled in
Uh,
on 31 on
17-10-2000. There are two agreements. 17-10-2021
2021
and 30-10-2020.
30-10-2021, comma. The same are still yet to be finally settled. Mr. Be that as it may, comma. He submits that Since
And
the-
land is still,
the- Since the land being the ancestral property which are yet to be finally settled, there is no question of trespassing. Therefore, the FIR, the proceedings, the charge sheet as well as the consequential proceeding, FIR and the charge sheet and its consequential proceedings being GR case number 24 of 2021 under section 447 427 506 and 34 of IPC. Maybe set is and was. Next. Mr. O. Modi, learned counsel to the respondent on the other end submits that the land has been, the land in question, land involved in the land at 5th Mile, Masigat, has been settled, has already been settled in favor of the petitioner. Respondent number 5 as the share of the ancestral property. Mr. It is Mr. There is no dispute that the petitioner has entered into the land of the petitioner. Respondent 5 and threatened and said they were the levelers and also threatened the respondent 5, by trespassing into the land of respondent 5, the petitioner has committed the offense which the investigate for which the on proper investigation and on the basis of the witnesses, the charges has been rightly, and this charge sheet has been filed and the trial is pending. Therefore, there is no ground for washing of the closing of the year case number 24 of 2021, pending before the learned CGM Pasigat. Then what is your submission, Mr. G. Thado? Learned counsel, learned additional PP
Yes,
submits that.
question of trespass only depends on the whether there is a clear clear owner of the land or not. But ownership of the land is still
Submits that. From the records, it appears that the right, title and ownership of the land is yet to be finally settled.
yes.
Therefore, prior facie, there may not be a question of trespass
Yes.
as the trespass would be applicable when a person entered into the land of
Private land.
private land of other person without any authority under the law. Therefore, he fairly submits that this court may consider for passing appropriate order.
Yes.
Next page. The consideration has been given to the submissions of learned counsel parties and also where is the records produced by the records, where is the trial court records? Scan copy of the trial records produced by the, this is produced by you,
And no, this is
trial court records. Okay. Trial court
LCR, it's a court record.
It is not disputed that the petitioner and the respondent, probably respondent number 5, are the relation by blood, being the descendants of same grandfather. These two. The records reveals that the land involved appears to be not finally settled between the parties. Although by an agreement, by referring to the agreements of both the parties, vehemently makes the submission that the petitioner, the land involved has been settled in favor of the petitioner as share of ancestral property, and the respondent strenuously argued that same is yet to be finalized. Next. The materials to be considered in the present case, in my view, is not to the ownership of the land by either of the party. Since the charges against trespassing under section, the charges basically under section trespassing under section 447 of IPC. It is to be the material to be considered is to, as to whether the respondent number as to whether the petitioner has transferred into the land of the petitioner. Respondent number 5. Next page. On consideration of the record, and the statements of the witnesses, it is seen that the respondent, the petitioner, has indeed entered into the land at 5 million, which claims to be belongs to the respondent number 5. Mr. There are materials to indicate that the petitioners, the respondent 5, the petitioner has made an has stopped the construction work on the land and the laborers were also been said they were. So the disputes appears to be purely of civil nature. The act of the petitioner cannot be lost sight of. Next, matter, having considered the materials, this court is of the view that the present case is not one of the cases where the inherent power under Section 482 of CRPC is fit to be exercised. In view of the discussions made here in above. On considering of materials, this court is not inclined to watch the president, the first proceedings of GR case number 24, 2021 under section 447 of the 427 of the 506 IPC. For 47, 341, 506 IPC, pending before the learned CGM. Pasikat. Accordingly, the present criminal petition is dismissed. It is made, however, it is made clear that any observations by this court in this present proceeding shall not be construed to be a observation and decision construed to be a observation touching the merit of the criminal proceedings pending before the CGM as the guilt or otherwise of the petitioner, public accused, decided on its own merit by the learned trial.
Obliged.
22. Why this has been missed? Yes.
Notice was issued by not,
Why this?
my learned friend is entering
My
appearance.
first appearance today for the respondent.
And not
I
take up
filed
this
my
matter.
wakalat number.
List before any other appropriate bench. So,
Deeply up.
I'm sorry, I'll not say that I'll not take up. I would not like to take up.
I understand. Otherwise, it's a total abuse of procedural record.
Yes.
Lordship, leading counsel is there in this session court. Then this matter will pass over.
Who?
G. Kato. G. Kato.
Ah,
Your Honor, he is in session court.
so
This matter will pass over.
that cannot be ground. Is it your instruction by your senior?
Yes, Lordship.
You tell your senior to have some better practice as a lawyer. You learn from your senior, you ask him. This is not the way. Ask Mr. Panging also. This is not the way. How long you have been in practice?
Your Honor, it's been 4 years.
4 years.
Yes, Lordship.
Have you not been to the court?
Yes,
How
Your Honor.
how the mention and how when I mean on what ground mention are being made? Have you not witnessed anything? Have you not learned anything?
No, Lordship, I have been
During these
learning.
4 years.
Yes, Your
On
Honor.
what ground adjournment is sought? Is sought? How the prayers are being made before the court? Learn something,
Yes, Lordship.
including ask your senior to
Yes, Lordship.
learn more the practice and ethics of the court. This is hearing.
Yes, Lordship.
Who is for respondent?
T. Torum, Lordship.
We'll take up at 2.
I love this.
Call your senior. One more. Yes, anything else? Huh? You think or are you sure? Are you sure or you think? We'll take up this item 28. Where is this? Where is this lawyer? You ask your senior to come at 2 o'clock
Lordship. Yes, Lord.
and inform the other side.
Yes, Lord.
T. Torum will dispose of the matter at 2.
I love this, Lord.
From the opposite counsel, and because of oversight, he has not seen the matter was listed, and this morning he has left for 0 with his family. So he's asked to
Left for where? Left for where?
left along with his family to 0.
Hmm.
So he's asked me to adjourn this matter.
But you instruct your client, junior,
Yes, I'm so sorry.
not to make mention like that, even if you are busy. We understand. What is to be done? What is the matter?
My lord, this is a civil division.
Hmm.
I'm challenging the trial de novo conducted by the learned CGM UPR.
Hmm.
My lord, here in this case, initially I had filed a suit for reduction of interest. And in the suit, my lord, 5 issues were framed and all the issues were decided. And while deciding this matter, my suit was dismissed on the ground of maintainability.
Hmm.
Thereafter, Lordship, I approached this honorable court by appeal, and this honorable court was pleased to remand back the matter with a direction to determine the rate of interest.
What is that order? High Court order? Page 64.
Lordship, it's 63.
No. 63, 60, it's here, it's 63, 64. RFA 4.
Yes, Lordship. Lordship is page number 69 and operative portion is last paragraph.
Judgment or decree so and so performed by the learned civil there by settlement and the suit is given with the learned public petitioner that
Lordship, here the direction was only to determine the rate of interest,
if so advised.
whether the rate of interest is reasonable or not.
Determine whether the rate of interest in question is reasonable or not, taking into consideration the giving a opportunity of adducing additional evidence to both the sides. If so advised, and then to dispute.
My lord, here
What
the
was the claim? Your claim was for rate of interest,
for reduction of rate of interest. For reduction of rate of interest.
in the suit,
Yes,
in the suit.
yes. My lord, here I am the borrower and I filed the suit for reduction of interest.
Okay.
The fact is that I've taken 70 lakhs on 3 different occasions altogether and I've returned 79 lakhs. So I've approached this court that the rate of interest that is 10.
Has it been adjudicated? Was it an issue? After this, any rate of interest has been determined?
No, my lord, here what the learned judge has done is that he has framed the issues that were already been decided.
Maintainability,
Maintainability, my lord, here after filing RFA, this case has been remanded back for trial. And here my lordship here,
what is the impugn order? Impugn order.
impugn
You
order,
went up
lordship,
to
it's
Supreme Court.
71, page number 71, annexure 6.
70?
71.
71.
Yes, lordship.
Case is fixed for framing issue on pleading of the parties. 5 numbers of issues were framed in separate second. Parties shall file the list of witnesses. 71 is list of witnesses.
No, lordship, this is the order 71 and 72 is the issues framed by the learned court.
Then
Lordship, my contention here is already issue number 1 and 2 has already been decided. So this issue has been framed again. And no cross objection has been filed by the respondent regarding these 2 issues. Meaning thereby this has attained finality.
decided by whom?
My lord, in the title suit which was dismissed, these issues, all the issues were determined. But only on the ground of mentality, the suit was dismissed and all these issues 1 and 2, it was in my favor. Lordship, here the learned CGM has misinterpreted the direction of the Honorable Court where it is.
You went up to Supreme Court.
No, my lord.
What you have annexed in? Okay.
My lord, this is for limitation.
Okay. So what is to be done?
My lord, this may be fixed after 2 weeks.
Mr. G. Kato, learned counsel for the petitioner, is present. So heard Mr. G. Kato, learned counsel for the petitioner. Non appears for the respondent. List after 2 weeks.
Yes, ma'am. Obliged, ma'am.
All right then, I'll pronounce it. Acquittal on benefit of doubt. All right, thank you. Ete.
Thank you.
Mm.